After a divorce mediation, do you have 30 days to change your mind? I'm told Attorney James Wirth that is the question that we have received. If you do a divorce mediation family law case here in Oklahoma, an agreement is reached on that date of the mediation, do you have 30 days thereafter to change your mind? And the answer is no. Generally, you do not have any time after a mediation agreement to change your mind if it's done properly. Now, typically, if you're doing a mediation, sometimes it's by agreement, sometimes it's court ordered before you go to trial. Some counties that are busy, like Tulsa County, they require mediation pretty much in every case before you can get a trial date from the judge. But other counties may not require it. In any sense, if you're going to mediation, whether it's agreed or not, in order to leave mediation with an agreement, it does require in agreement. So all parties have to be in agreement. Typically that's two parties. If it's a divorce, husband and wife, they agree to that, and then it's typically memorialized. Sometimes that's done at the mediation, sometimes afterwards. By memorialized, I mean it's drafted up or it's written down on a piece of paper. This is the agreement, and both parties, and if they have attorneys there, their attorneys sign it as well. At that point, the court generally treats it as a contract by the rules of contract, and it's enforceable inside the divorce case. So if a full, complete agreement is reached, and it's drafted up and it's signed by the parties and their attorneys, at that point it is binding and you don't have time to change your mind. That said, you never have to reach an agreement at mediation. You can mediate and you can turn down all of the offers. It is not binding, it is not arbitration, it is not a trial. So if an agreement is not reached, you simply don't agree and you want to generally, leave with their best offer and you haven't given your best offer, but if those two offers don't overlap to where an agreement can be reached, then you leave mediation without an agreement. But if you do have an agreement and it's memorialized and it's signed, it's generally enforceable. Okay, so what if you go to a mediation, an agreement is reached, but it's not written down, it's not signed off on? At that point, enforceability can be problematic. Generally, it won't be enforceable because there's no clear evidence from what the agreement is. So if one party says it was one thing, another party says it was another, the judge is likely to find that there's nothing to enforce here. So if you're wanting to go to mediation and you have an agreement, you want it to be enforceable, make sure it's drafted up quickly, signed by all of the parties, and that the terms are super clear. Otherwise, enforceability is going to be a problem. That's one more thing you have to litigate, which increases cost and expenses, particularly if it may be enforced by the court and may not, depending on the circumstances. But as far as this blanket rule that you have a certain amount of time to change your mind, that's not a thing. That doesn't exist. If an agreement is reached and signed, it's enforceable under contract law inside the divorce case. If you're going through a family law case in the state of Oklahoma, though, you don't just want general advice. You want to speak with an attorney privately and confidentially to receive legal advice. To get that scheduled with an attorney at my office, go online to makelawEasy.com.